And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You here on 4CRB. Your opportunity for free legal advice between now and 9:30, that's 10:30 Tweed Coast time. All we need you to do is get on that telephone as soon as you possibly can, 55208888. That number again, 55208888. 07 in front, of course, if you live south of the Tweed River. And we say good morning to our very first callers who are very quick out of the blocks this morning. Peter, g'day Peter, how are you today?
Good morning, hi.
How can I help?
Oh, hi, good morning. Yes, I have a question regarding power of attorney.
Sure.
I gave power of attorney to some members of my family several years ago.
Yep.
Some changes in the family circumstances have arisen, and I now wish to cancel entirely that previous power of attorney.
Yes.
What are the protocols for ensuring that power of attorney is cancelled?
Right, so are you wanting to put a new power of attorney in place, or are you just wanting to cancel the existing?
Not immediately,
all right.
Not immediately, but in the near future I probably will, yes, but I want to cancel the
all right, well, all
one.
you need to do then is do a revocation of power of attorney document, Peter. So are you in Queensland or New South Wales?
Queensland.
Okay, yes, so there is a form, a statutory form, which you can complete with your lawyer, or if you're computer literate, you may be able to download it from the government website. I'm not sure if you can still buy those forms at the newsagent, but that might be another possibility. And all you need to do is fill that form out. It does need to be witnessed in the same way that a power of attorney needs to be witnessed. So in other words, it needs to be witnessed by a solicitor, by a justice of the peace, or a commissioner for oaths. And then you need to send a copy of that document to each of the attorneys just to let them know that the power of attorney has been revoked.
Okay, all right. Thanks.
So that should help you out?
Yes, that's fine. Thank you very much.
Okay then, Peter, all the very best. Time on 4CRB, just coming up to 8 minutes past 9 past 10 on the Tweed, as we say a very good morning to Mary. G'day, Mary. How are you today? Mary, are you there?
Yeah, I'm coming. Are you there, John?
I am here indeed. How can I help you today?
Okay, just when I moved away from the phone, you rang. Okay, thank you, John, for taking my call.
No trouble.
This is regarding superannuation, which I know nothing about. But my daughter died at the age of 45 all of a sudden. And later on we found out her superannuation, she wanted her only daughter to inherit that.
Yes.
Now, what happened to a superannuation? Whoever took in charge of it as a trustee, and this incident happened about 10 years ago, that person is her auntie, I don't think the word is adopted her, but guardianed her?
Guardian.
Oh, thank you. Yes. I'm not good at English. That's like okay. That. As long as you understand.
Yes.
And she put her in an expensive school and looked after her very well because she could afford it anyway. Now, the daughter, the last year, thought now that she is about 25 years old, want to start living, and she needed 10,000 to rent a place, put bond money, and shows that she's got money. Because she was counting on this superannuation money, which is about 30,000. So when she rang me, and she said, I'm going to ring up my auntie to blah, 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 blah. Oh, I said, you missed the boat. I said, auntie is holidaying in Europe. For how long? I said, 6 weeks. Oh, no. I said, what's wrong? And she said, I need 10,000 of the superannuation. And she was desperate because she already talked with the manager and all to get this unit, the bedroom unit. Can you help me? I'm a pensioner. I said, the answer is yes, because I knew of the superannuation money. She said, when she come, the auntie, you know, Nana, I said, no problem. I went to the bank and I arranged the 10,000. and my granddaughter was happy.
Yep.
Everything's going smooth, and I'm trying to keep the family going as well. But the problem is, when the auntie came from holiday and my granddaughter told her what happened, she said, I'm not parting from 1 cent.
Of the superannuation money.
So the situation is, John, is this. Can she do that? So my granddaughter got what she wanted.
Yep.
I'm at a loss of 10,000 for trying to help.
Right. Well, it'll depend on where the super was held. Was it held in a industry fund or a retail fund?
Where I think it was put in a.
Did it come from her employment? Did it come from her employment?
Whose employment?
From your daughter's employment. Was this the super deducted out of her wages, or did she have a self-managed superannuation fund?
No, I think I'm not with it at all. I knew nothing about superannuation.
Well, look, it depends on the nature of the fund, but if it was an industry fund or a retail fund, then the only persons who could have access to the super payout is someone who qualifies under the legislation, and that is a dependent child, or a spouse, or someone who is legally dependent, or the legal personal representative of your daughter, so someone who might have been the executor under the will. So I think what your daughter needs to do or what your granddaughter needs to do, or you need to do, is find out who your daughter had a superannuation with, and then I think your granddaughter needs to speak to them to find out what happened to the payout under the super, because it normally would go to one of those three parties, depending on whether your daughter had put in place a binding death benefit nomination or not. So I think the short answer to your question for the moment, Mary, is that your granddaughter should get onto the company that your daughter had her superannuation with and find out what happened to it following your daughter's passing. All right, but we'll have to leave it there. I'm sorry, Mary, because we've got other callers online. And the other thing you can do, Mary, if you can get that information, ring back to Finance Forum on a Thursday morning, because they have people who would also be able to help you with probably more completely with the issue of superannuation. All right,
thank you very much. I appreciate it.
Okay, Mary, all the best.
Bye.
And the time on 4CRB, 13.5 minutes past 9, of course, past 10 on the Tweed. As we say, very good morning to Jan. G'day, Jan. How are you today? Jan, are you there?
Yes, I'm here.
How can I help you today?
My daughter separated from her husband, and the family home got sold, and it came in for less than what they owe on it. He has declared bankruptcy. The house was in his name, but the mortgage was in both of their names. Who is responsible for the rest of the debt?
Well, it'll depend on the terms of the mortgage, but I suspect, sadly, that probably your daughter will be, Jan, because under a mortgage, if it's in both names, normally it provides that the parties are jointly and severally liable for the debt, which means that if they can't recover the debt off half the debt off the husband, they will normally go after the other party to the loan agreement for the balance. So the first step will be to for your daughter to get some advice in relation to the mortgage document itself. Whereabouts does your daughter live?
On the Gold Coast.
Okay, well, look, she could possibly go to the the Gold Coast Community Advice Service, so the Gold Coast Community Legal Centre. Have you got a pen handy? I can give you a number.
Yes.
Okay, so their number is 5532 9611. So they do operate a number of clinics up and down the coast for providing legal advice. So if you rang that number, you could find the one that's nearest to where your daughter lives and is at a time that is the most convenient to her. Or if she lives in the Robina area, she could go to the My Community Legal, which previously was known as the Robina Community Legal Centre. It operates in the Gold Coast City Council Robina Community Centre there, just near the town centre, on a Thursday evening from 6:30 until 8:30 every Thursday. You don't need to make appointments. You just rock up at 6:30, and they normally have a number of lawyers there. And what I would suggest she do, though, before she does that, is get a copy of the mortgage or any other documents she signed with the bank, so that she can obtain appropriate advice as to whether the mortgage does in fact provide for joint and several liability. But as I say, look, Jan, quite frankly, I think it would be highly unusual if it did not.
Oh, okay then. Well, thank you so much for your help.
Okay, sorry I can't give you better news.
That's okay. Thank you.
All the best. Time on 4CRB is just coming up to 16 and a half minutes past 9. That's, of course, 16 and a half minutes past 10, daylight saving time. We did have a couple of emails that came in the last few days. I didn't have an opportunity to this morning just to remind you that if you do have a question or a query, you can send it in to us at talkback@4crb.com if you're not able to call the program on a Tuesday morning. There are obviously some people who are working and may be able to listen to the program, but necessarily can't ring in, or you might be driving in the car, and of course we don't want you touching that mobile phone while you're driving, lest you incur the wrath of the police and a very substantial fine. So there is that service available to you to send emails into talkback@4crb.com. And one that I did get, which I will answer separately by email, but I thought I would just read out to you. It says, I'm not able to hear your program due to being away most Tuesday mornings, but I was very impressed with the program. My problem is I'm 86 years old, live on my own. I have no real close friends left, but I have a daughter who lives in North Queensland. She has a copy of my will and the enduring power of attorney. What I do not understand is if I am in need of her to carry out any financial duties, could you please advise me on what are her lawful procedures she needs to follow to look after the finances in case of emergency? Well, of course, the first thing to look at in your power of attorney is whether the power of attorney says that it takes effect immediately for financial matters, or whether it says that it only takes effect when you lose capacity. If it takes effect immediately, what you can do is that you can get that power of attorney recorded with your bank or other financial institutions that you deal with, so that in the event of something going wrong, a loved one would be able to take over and look after things for you. Alternatively, if it's just that you want to make that change now or when you lose capacity, you'd need to make sure that whoever holds your power of attorney has a copy, so that they can go and see the bank or other financial institutions so they can look after things for you. But probably best to have that in place, particularly if it's a trusted family member that you're using as attorney. But enough of that for the moment. We have a couple more callers online as we say good morning to Brian. G'day, Brian. How are you?
Hello there.
How are you, Brian?
Not too bad.
That's good.
What I'm ringing up about is I'm an executor to a will, and the will has been contested.
Mm-hmm.
Now, I've been living at home all my life and that, and I just wanted to know if in the will, because I've partially been left, half the house and that, would living at home all my life have any effect on the will, or could I register for domestic partner?
So you were living with someone, were you? I've
been living with Mum and Dad all my life.
Right.
And they've both passed away now.
Right. Okay.
And I've been paying all the bills.
All right. And so you've been left half the house, or have you been left the whole house?
Half.
Half the house. Okay. And someone's contesting the will. Do you know what they're claiming for?
Well, I think they're on the grounds that they want the house sold to get a bigger share than what they have been offered. They've been offered monetary amounts, and my younger sister and I have been willed half the house.
Right, okay. So does the house have to be sold eventually?
That we don't know. This is what I'm trying to inquire about.
Well, what's to happen to the other half of the house?
Well, it's in the name of my sister and I.
So half the house has been left to you and your sister. Is that what you're saying?
Yes.
Okay, and there's some other sibling who's claiming for something else.
Yeah, they have received monetary amounts as well by Mum.
Right.
And her wishes was for my younger sister and I to have half the house, and they are contesting, saying that they're not receiving enough
an adequate
out of
provision.
The will.
Yeah, well, that's the normal grounds for making a claim. Brian, look, I think what you really need to do is get yourself some legal advice in relation to this from someone competent in these sorts of matters. There's a lot of research that needs to go into this to determine what the likely outcome will be. One of the things that needs to be looked at is your financial position, the financial position of your sister versus the financial position of the claimant.
That's what my
all of those,
said, yes.
All of those sorts of things need to be looked at, and whether also the behaviour of the other sibling towards your parents during their lifetime, whether they were, didn't really have much to do with your parents and were neglectful of them. All of those sorts of things come into account. Is this in Queensland or New South Wales?
In New South Wales.
Right, okay. Well, even in New South Wales, they do have procedures whereby they endeavour to mediate a settlement, so they do have compulsory mediation prior to a matter going to hearing. You are far better to try and resolve the matter before you go to hearing, because if it goes to hearing, of course there are going to be substantial legal fees all round.
Yes, that's where the house would have to be sold to pay lawyers' bills.
Yes, and that's, of course, something that you want to try and avoid. So there's not a great deal of assistance I can give you further to that on this program, Brian, simply because it really does require going into the facts and circumstances of the case to determine. So your lawyer is going to be the best person who can advise you on that, and just to make sure that you've got someone advising you who is competent in this area, and by that I mean someone who does work in this area, so they're familiar with what might likely happen. The other thing that's going to be important too is the selection of, if it gets to the point of mediation, you may need to get a barrister involved, and again to get a barrister who is experienced in this area as well. All right then. Okay, Brian, all the very best. Time on 4CRB, 23 and a half minutes past 9, past 10 on the Tweed, and we say good morning to Carol. G'day, Carol. How are you today? Hello, Carol. Are you there?
Oh, John.
Yes, how are you?
Good, thanks. I just want to know, when one makes out a will, there's the names and their addresses, place of residence.
Yep.
If at that place of residence they move to a different address, do we have to change the will to those addresses? No.
So the fact that you have a new address, in fact, not infrequently I have people call me on the program saying I've moved from a different state of Australia. Is my will still valid now that I'm living in Queensland or New South Wales or wherever they happen to have moved to? And certainly that does not in any way impact the validity of your will. As long as your will was validly made in the first place, a change of address is certainly not going to affect the validity of the will.
Can I ask you something else?
Sure.
My son lived in a de facto relationship and they're separated. But he has a superannuation. He has no will made out. But I wondered, would it be best to see a solicitor, or can we just get the will forms and be witnesses and say about where he wants his, if anything happened to him, where his superannuation?
Well, it'd be advisable for him to put a will in place. I assume from what you're saying that he's probably in an industry fund, is he? Or a retail fund? It's not a self-managed superannuation fund.
No, yes,
Okay, so the first thing he needs to look at with that, Carol, is whether he can put in place a binding death benefit nomination. Now, depending on what retail fund he may be or industry fund he's with, he also needs to check whether he can do a non-lapsing binding death benefit nomination. Because if he doesn't do that, were there any children to the relationship or not?
Yes, there's the children.
So if there were children to the relationship and there is no binding death benefit nomination in place, even if he's simply got a death benefit nomination but not a binding death benefit nomination in place, the trustee of the super fund can overrule that and can decide where they're going to pay the super to. So, there would be, a strong possibility if he has no binding death benefit nomination in place that it would automatically go to his children. So, depending on the amount of insurance and everything involved in his super, it very well may be.
He does want he wants them to go to his children.
Yeah, but he may not want it to go to them. How old are they at present?
Oh, they're only young, 13, 10.
Yeah, well, see, he really does need to get some advice in relation to this, because if he's got insurance attached to his super, it could be quite a substantial sum of money. And if the children are simply the beneficiaries of the super, then they will get the money at 18, and it may be more money than he would like them to have at 18. So what he could possibly do is firstly do a binding death benefit nomination in favour of his legal personal representative, which is the executor under his will, and then put a will in place that puts in place a trust to look after that money for the benefit of his children until they reach an age where he thinks that they'll be okay to look after it themselves.
That's right. And the citizen's advice, would be best to go to a solicitor.
I think,
citizen's advice.
Yes, I think you would really need to. He would really need to see a solicitor, I would suggest, and someone who does a fair bit of work in the area of wills and estates.
The superannuation.
Yes. All right then.
Thanks, John.
Okay,
Thanks
Carol. All the very best for that.
Good.
And the time is just coming up to 27.5 minutes past 8. That's of course past 9 on the Tweed. Thank you to all the people who've called in this morning. I do have one last email which I'll share with you. The person who's written in says, I heard someone lost their house after being sued for hitting someone with a golf ball on a golf course. Apparently their house insurance didn't cover them. Is this correct? And if so, how can they be covered? Well, whether you're going to be liable for hitting someone with a golf ball on a golf course is not just a straightforward question, surprisingly enough, because just simply by playing golf, you do accept certain risks on the course. There is obviously always a risk that you can be hit by a golf ball. But one of the things that you can do in relation to your insurance to alleviate this is, in addition to having your household insurance, which normally has public risk insurance attached to it, you can also put in place what's called personal liability insurance. Many of the insurers will put that in place as well to cover you in the unlikely circumstances that this happened. There was a case in Brisbane quite a few years ago, I think, where one golfer who was playing in a 4 hit his ball, and there was a doctor down the course playing in that 4, and the fellow who hit the ball hooked his shot. He was an experienced golfer, but he hooked the ball, and he yelled out a warning, and it hit the doctor in the eye. But in that case, the court held that the person who hit the ball wasn't liable because they were a group of experienced golfers. The doctor who walked down the course elected to walk in front of where the other player was going to hit his ball from, and a warning was shouted, and so as a result of that, the court held that there could be no claim. But I think the best thing to do really would be to make sure, I think everyone should really consider having personal liability insurance in place just for those unlikely events that may arise that you never think about. This is John Fradgley from the Bell Legal Group. It's been great to be with you this morning. I'll look forward to being back next Tuesday for another program, but until then, as always, goodbye and God bless.